Before I start on the conflict of interest laws, I might just add a little something to what Mark just said regarding the question of private emails. That is something that, again, has not been authoritatively dealt with by Kansas courts, but I will tell you that courts in many, or administrative bodies in many, many other states have held, I'm aware of opinions from Alaska, New York, Connecticut, and Texas that basically say if a governmental official chooses to conduct governmental business on their personal cell phones or through their own Facebook things, that they have essentially waived their right to any privacy. Texas enacted a law that took effect September 1st that basically says if you, same thing, you conduct public business on your private email, it is a public record, just flat out. So just take that as for what it's worth.
So that brings up a question, and I apologize for speaking out of order, Vice Mayor, but so there has been a push to have our personal cell phones have all of our email communication, personal and our Wichita.gov communications on our cell phones, kind of as a cost-saving measure, So what you're saying is if we receive our Wichita.gov emails on our personal devices, we may be waiving our rights to everything else on that phone as well?
That's a possibility. Now, I know that in one case, and I believe that the case was in the Connecticut case I mentioned, ultimately that ended up with somebody being, this case resolved itself, but the administrative body was going to basically order an independent person to go in and do a search of both things and pull out only those things to be released that related directly to the government, so that everybody didn't have wide open access to the individual's email. But I think a potential exists for that. So there are certain problems with a bring your own device idea in government, for a variety of reasons, including your own personal privacy.
And can I
yeah.
Can I interrupt? We've disseminated a bring your own device policy for the council members, and that policy basically says that if you're going to have your city email information on your own personal device, then anything that is city related would be something that would be subject to the open records law if there's not an exemption that would exempt that email from the open records law. We also indicate that your personal email that is on your device is not subject to the open records law unless you're conducting city business, like Mark indicated you were conducting city business. So we have a policy in effect right now that addresses those issues.
So is that because those emails go directly to different servers, and so it's that server?
They're on the city servers, yes. That's what happened, is they're going through the city server, but the personal emails are not going through the city server. They're coming to you, to your device. Mm-hmm. But the ones that come through the city server are the ones that we acknowledge that if it's public business, then it could be subject to open records.
That's what I was going to point out just quickly. From a real-world point of view, we do this a lot in law enforcement. I want to get access to a suspect's emails, text messages, etc. It's not the device necessarily that's the issue. It's because the device itself has a very short-term memory. It's the servers. It's the mainframe. It's Google that may have your Gmail on, and you can serve subpoenas to that entity, which will maintain it. So, if you use, I'm going to use my personal iPad that I bring from home, and therefore, Katie barred the door, I can say, well, the device is not really the thing. It's more, what are you doing? Is it government business? Is it personal business? And that's really what's more important than, did I pay for this, or is it a county issued thing?
So if we do business with our personal business on these devices, just because we may receive city emails on these devices does not make our personal emails subject to
That's right.
CORA. Okay. All right.
It's only government business.
All right.
Okay, conflict of interest, that's what we're going to talk about for a little bit. The legislature enacted certain regulations to prevent governmental officials for basically self-dealing, enriching themselves because of their governmental position. So the law was enacted to prevent that, as well as to make sure that the electorate was informed of the substantial interest that a candidate or elected official has. All of you who ran for public office know that you had to file a statement of substantial interest with the city clerk but when you announced your candidacy. And so you all have been through that particular process. The reason that that is required is because the law prohibits certain things. It prohibits officers and employees of a governmental body from making or participating in the making of any contract with any person or business with whom you have a substantial interest. That means basically you can't make a contract with your family business, Fannie Mae's. You just can't do it. And likewise, it prohibits Fannie Mae from making a contract with you. So you could be liable under the law, and family business Fannie Mae's could be liable under the law. Two possible violations by the company and by the officer or employee. So this does not relate just to you as elected officials. It also relates to employees of governmental units. Again, there are always exceptions to every rule. Those prohibitions do not apply to contracts that have been let after competitive bidding, and there's been published notice of that, or to contracts where the property or services price has been fixed by law. As long as you take no action, and by action we're talking about the exercise of power or authority or the performance of an official duty in relation to any matter. So as long as you stay away from any of that, you're safe.
The majority of our contracts are let by competitive bidding, but yet we still ratify them at the bench typically. Are you saying that if it went through the competitive bidding process, even though we're ratifying that at the bench, then there is no issue with substantial business interest? Or
that's right. As long as there is published notice to everyone as required by law regarding that is correct.
Okay.
Violations of the conflicts of interest law are a Class B misdemeanor. And in this case, you wouldn't have to worry about that kind of violation causing a recall or a ouster petition, because a legal forfeiture would be worked on your office and you would lose your position. Same with any employment. If they're convicted of a violation of those laws, you lose your office, they lose their employment. It's just that simple. In regard to non-elected officials, your general employees, they didn't have the wonderful opportunity like you did to file a statement of substantial interest because they never ran for anything. But sometimes public employees have a substantial interest in a business with whom they may be engaged in business. They may be working on preparing a contract. They may be taking some action regarding something. And if that is the case, they are required to file something that is very similar to your statement of substantial interest. It is a written report setting out their interest. They've got to file it with the county election officer. And they must do this before they take any action in regard to a matter that ultimately may result in a contract being made. If they do that, they're okay. And if they abstain from taking any action, they're doubly okay. But even if they file that and end up participating in the making of a contract, they would still be liable under the law. And again, a violation in that regard is a Class B misdemeanor. Okay, so what are we talking about when we're talking about a substantial interest? These things involve both you and your spouse. Individually or collectively, if you hold certain assets. For example, if either of you has a legal or equitable ownership interest in a business that is worth $5,000 or 5% of the business, whichever is less, you have a substantial interest. So even if your business doesn't make a dime, if that's something that you own, you have a substantial interest in it. If you receive income from a business or a combination of businesses that is $2,000 or more, you have a substantial interest. If you get goods or services without basically compensating them for the goods or services in an amount equal to or over $500, you have a substantial interest.
Pardon me, does that include your employer?
Yes, it does. And that's specifically what was referred to in that bottom bullet. And again, without regard to the amount of money you received, if you or your spouse is an officer, director, partner, et cetera, of a business, you have a substantial interest in that business, other than certain 501c3 or C nonprofit corporations. There's a variety of them. Not all of them are included, but the vast majority that you'd be familiar with, like a C3 or C6, would be excluded. If there's a business in which you or your spouse get a portion of the commission that is paid or fee that's paid for every transaction that is done with a client or customer, and by that we're talking about business entities, in the amount of $2,000 or more in the preceding year, you have a substantial interest. Okay, so to make sure that we're clear on the terms that we've been using, the operative terms are described right here. Again, the acts would be an exercise of power, authority, or the performance of any duty incident to public office or employment. And businesses are just about any kind of business form that you could conceive of, including ownership of land that you would rent out. But trusts, even if you're a trustee, that would be a substantial interest that you must report. Compensation, basically anything that's of economic value. Employee obviously has its usual definition. An officer, again, either an elective or appointed officer. Okay, substantial interest statements. You all know where they are to be filed since you've done it. Yes, sir.
On the trustee, if you're a family trustee, a family trust account, you don't have to disclose that, do you?
Yes, you do. If you're the trustee, you do. You've got to disclose a lot of things. I mean, you've got to disclose stock ownership. You've got to disclose interests in mutual funds. You have a retirement account. You've got to disclose that. All those things must be disclosed.
You have to disclose those if we're doing business with any of the, if the city's doing business with any of those entities, that has to be disclosed, or no, we need to disclose all of our retirement accounts. For example, I've worked for 5 different employers, and I probably have 5 different retirement accounts. Do I need to list all of those? We don't necessarily, as the city of Wichita, do business with any of them, but.
Right. No, I understand the point you're trying to clarify, and the answer is whether you do have anything to do with the city of Wichita or not, you must list those. Yeah. And that's by Governmental Ethics Commission rule, basically. You wouldn't necessarily read that through the definitions in the statute, other than their business definition is very expansive, but the Ethics Commission itself requires that, and their forms set that out. So, as I mentioned before, a position, corporate position with a nonprofit generally is not considered to be a substantial interest. Nonetheless, the law requires that you report that. So if you're on a, you're on a board of a charity, you got to report it even if it's not a substantial interest. Actually, I want to go back here again. Yeah, the Governmental Ethics Commission I mentioned is the one who prescribes the form and tells you what the prescribed disclosures are, and we'll go through those again here in just a minute. First, let's talk about a little bit about your filing times. Generally, most people file for office within the filing time, and they don't get to run for office. But occasionally, there will be someone who will withdraw their candidacy or a death happens, and so there's different time schedules to take care of those kind of possibilities. So 10 days after the deadline for filing, if you actually met the deadline, or if not, within 5 days of your becoming a candidate. If you're appointed to fill a vacant elective office, the appointment takes place before April 30th, then you must file your statement between the time period there. And afterwards, after April 30th, within 15 days of appointment. If you are currently holding office, you must file any changes in substantial interest that occurred during the preceding year between April 15th and April 30th. So just remember, anytime you've got your tax deadline, you've got to pay your taxes, you also got to think about, have I acquired any new business interest that would be construed as a substantial business interest? If so, you've got to file an amended substantial interest statement. So if you start a new business, if your spouse starts a new business, if you acquire new stocks even, according to theirs, you've got to file those. Every year there must be an amendment if your substantial interests have changed. So, and again, we're talking about the governmental ethics form. They basically say you got to report it all: stocks, retirement accounts, mutual funds, and businesses operated out of your home, regardless of whether they're making much money. You don't need to report, however, shares in a credit union, annuities that are not part of a retirement plan, notes, bonds, and a few other things. They are listed in the actual form itself if you want to see, and you can find that on the Governmental Ethics Commission website. Yes, ma'am.
So if you have an account at a credit union, technically you have shares in it, right? Because they're member-owned. So all credit union accounts that we have to list.
You do not have to. This is an exclusion.
But this is an exclusion.
The bottom bullet is
I'm
an
sorry.
exclusion.
Okay. Oh, okay.
But your point is well taken. You would think normally, since credit unions are shares of ownership, you'd have to report, but they say, nope, not in this case. But the other things you do: stocks, retirement accounts, but not bonds, not credit unions. Okay. Now, have I confused you thoroughly?
Going back to substantial interest, my wife and I own a company. Certainly that company is on our list of substantial interest. But do I need to also report every single customer and the dollar amount I do with them on that form?
No. Just the entity itself.
Okay.
Other questions?
I think maybe this is the question you asked, James, and I didn't understand it at the time. If we're employed elsewhere, in addition to this job, do we list that employer too because we receive compensation from them?
You do if it meets the threshold amount.
Okay. I think I need to publicly request a new statement of substantial interest.
It's good that we have these kinds of review sessions because these are the kinds of things that people can get caught up on. They just don't think about these kinds of things, and so it's always good to have a kind of refresher on these things because a lot of people don't knowingly not list things, but there's all sorts of stuff you got to keep in mind. So, okay. Any other questions?
But if an event happens during the year, you don't have to report that change until the next April 15th.
Tax season.
That's right. Between Thursday and the 30th.
Okay.
I would have one exception to that, is if there was a matter coming before the council that would involve that company, then you should make your change to your interest statement at that time.
Yeah, I would agree with that. I mean, you should. That's not the letter of the law, but it would not look good if you didn't.
Well, let's just say if you,
It might violate the city code of ethics and that kind of thing, so.
but if you just change jobs or something like that.
If you change jobs, that's something you're going to need to definitely report, yeah.
So if you're subcontract labor for a company, I know this is probably just a broken record, but if you do subcontract labor and you receive a 1099 from an entity and it's above that threshold, you have to list that on your substantial interest form. Right.
Okay, other questions? Thank you.